All right, Larry Lala here, and tonight I don't have a ton prepared. I wanted to take the pieces of what we've gone over for the last several weeks about how to prepare for law school the right way. I've given you lots of little bits and pieces, and I want to kind of put it all together for you. First, I'm going to kind of talk it through, and then I'm going to use my totally impressive artistic skills. Impressive if I were like 7. Um, Actually, that's not true. My art's like, um, it's an insult to 7-year-olds. Anyway, um, but I'm going to try and diagram some of this so that you can see it as well. And then we're going to hop into your questions about law school. Okay? So again, this time I'm going to put a lot of the ideas that we've gone over all together, and I'm going to try to present you a grand unified theory. Hold on a second. I want to get rid of this bar. At least try to move it. There we go. So this is the recap. You really want good grades in law school. Law school is kind of a means to an end to help you get the kind of career that you want to, but to really maximize your chances at getting that job, you need to have good grades. Part of that's for a number of reasons. It's a rough legal market. To get a good job, or in some places to get a job, you really need to be at the top of your class. And law school grades on a relatively harsh curve, so good grades are hard to come by. Good grades come from good final exam results. This is not like undergrad. In most law schools, the final exam is nearly 100% of your grade, or usually 100% of your grade. Some law schools are doing midterms, but not that many. And maybe there's you get a bump for class participation, but nothing more than, kind of a plus, uh, going up a third of a grade from a B to B plus or B plus to A minus. So you want good grades. To get good grades, you've got to do well on your final exams that completely make up your grades. To write a good final exam, you need to be good at the set of skills that are involved with issue spotting. To be good at issue spotting, you need to kind of do take a practice exam a day, which you don't have to take literally, but you do have to take seriously the idea that on a semi-daily basis, probably not less than every week, but at least a couple times a week, you want to take practice exams, because issue spotting is a skill. It's not a pile of knowledge. It's the practice of being able to take the law and apply it to completely new situations. That's relatively difficult. Okay, so we're a waterfall. This is the priority. This feeds into that. Issue spotting, developing good issue spotting skills is how you get good at final exams. Tapiat is how you develop good issue spotting skills. But there are a couple other things that you spend your time doing, and all of this will kind of feed into the end goal of getting good grades and doing well on final exams, if you do this right. First thing is cases. Why read cases? It's the thing that you're required to do in law school. It's the one thing that you're actually assigned on a daily basis. You're not assigned to do Tapiat. This is not what other law students will be doing. most law students who know what they're doing, who want to do well, are doing some form of tapia. But you have to read cases. So what's the strategy for you? What are you going to get out of reading cases? So you've got to read cases. Why? You're not going to answer this the same way as other students who just do what they're told. They're going to read and try and memorize all the details. There are specific things that you want to get out of reading cases. So you got to read cases. Why do you got to read the cases? To make rules of general application, that is taking the holding in a particular case and trying to figure out what is a somewhat more generalizable form of that rule that you can apply to future cases, right? So Hawkins versus McGee is the hairy hand case, in that the specific holding in that case is that you can't recover for pain and suffering under an expectation theory of damages, because pain and suffering is part of the contractual agreement. No matter what, a skin graft from your chest to your hand just sounds horrible and stupid as I say it, but it's the case, was going to hurt no matter what. So, right? So that's the general holding. The more generalizable form of that rule, and maybe this is way too general because it's a seminal case, is that expectation damages, you get to recover what you're entitled to under the contract, but only what you're entitled to under the contract, or that is to say, all of the good and all the bad that the contract would help you with. Okay. And if you kind of read cases of the way that I've mentioned, you're going to start to think through different hypos with that. Was, for instance, having a hairy hand kind of more painful than having 100% good hand? Is there chafing when you wear gloves that you wouldn't have? That kind of pain and suffering, or maybe there was some kind of heightened pain or suffering because it was done incorrectly. So you try to think about what are different forms of the case that would get me a different result, or what are different facts that would give me the same result, liability or not liability, but in a different situation. So why do you do these things? The hypos, I think, are more directly applicable to help you with issue spotting, because those are potential new facts that you could try to work through. But focusing on this, why do you do rules of general application? To fill out an outline. Why do you need to make your own outline? Because your outlines will contain different structures. These are two types of them. You could make a lot of things. But you're making outlines to have issue spectrums and case spectrums. Why? Because they help you issue spot better. Remember, the issue spectrum helps you figure out what, say, claim to pick. A case spectrum helps you resolve any particular claim. Under the IRAC framework, it'll help you kind of flesh out the different parties' arguments, and a case spectrum will help you kind of figure out how to conclude on a particular claim. Okay, so the reason you're reading cases, ultimately, it's a multi-step process, right? These are all interim steps, but all of them kind of march in a direct line to help you issue spot better. Other ways of reading cases, or other things that you might do, such as briefing cases, if you can't trace a relatively clean, direct line to learning to issue spot better, then question the utility of doing that particular exercise with cases. So briefing cases. Would you know the cases better generally? I mean, you can kind of filter it through this. How do you get to issue spot better by briefing cases? I don't see the line there. It might be very indirect. You might kind of know the cases a bit better in the abstract, but that's not a strategy, just to know the case, everything about the cases really well. There are certain things that come from the cases that are more important. This helps you focus on that. You put these together, you read the cases to make the RGAs, you make the RGAs to make outlines. In the outlines, you make issue and case spectrums, and those things very concretely will help you issue spot better. Class. Why do you go to class? not to understand the law in the first instance. That's something, okay, I'll come back to that. This is what I call mastering the professor. I'm not going to use my kind of normal master the law, master issue spotting, and master your professor framework. I want to try and come at it from a different way. But you'll recognize this. Why do you have to go to class? There are several things that you want to, you're laser focused on what's coming out of your professor's mouth. And there are three things that you want to get from your professor. One is when they're grilling a student and they actually take a case and say, let's suppose that Hawkins versus McGee was a little bit different. Your ears perk up and you write that down because that's a potential hypo. It's a potential alternative set of facts that the professor might come up with on the exam. Directly or indirectly, it gives you some insight into how the professor thinks about the world. You're listening in class for very specific statements of rules, either the factors or elements of a given claim. You know, battery is, say, according to the commercial outline, an intentional and offensive touching without consent. Maybe your professor glues together offensive touching and makes that one thing. That is the rule statement that you will use on exams. Or maybe your professor, a different kind of rule statement, is the RGA, the rule of general application that comes out of a case. But if your professor has a specific way of talking that through, you use exactly those words. Why? Because you're trying to make an argument, you're trying to sell your professor on the idea that you understand, that you're using your professor's language to try to communicate that you actually heard him during the year. And then lastly, you have, there are different ways of saying this, but favored modes of argumentation. That is, you can listen to your professor engaging in the Socratic method with other students, and you actually need to not just look down at your screen. You need to look at your professor's face, look up from your screen, and see how they're reacting to different things that are said in class. What do they like? What, in the more abstract form, what kinds of arguments do they like? Do they like counterintuitive arguments? Do they like law and economic types of arguments? Blah, blah, blah. Okay? Why are you doing these three things? All of this is to issue spot better than your classmates, to perhaps spot potential and think through fact patterns that your professor might devise, to use exactly the rule statements that your professor has come up with, the specific way that your professor words it, so that your professor actually understands your argument in a way that your professor might not if you didn't use the exact formulation that he did. And again, kind of favored modes of argumentation. All of that is to issue spot better. Now, remember, there's a different way of going about this. Maybe you're sitting in class for some attempt to understand the law. There are other students, I've missed class and borrowed notes, and some people take like verbatim near transcripts of what's being said in class. Is that really helpful? There's stuff that you have to sift through. Not most of it you're not going to use on the exam. So again, we kind of filter going to class through this to see if there's a direct line, even if it's multi-step, to getting to issue spot better so that we can do well on the final exam. Now, there's even kind of almost a deeper level of this. I talk about pre-studying or side studying the law. Why do you do that? Helps you read cases better. It helps cut down on the amount of time that you spend trying to figure out a case. Why do you want to speed that up? You want to get to make RGAs and hypos, and then you're going to outlining issue and case spectrums. So this is an aid to reading cases better. Why else do you want to pre-study the law? It helps you understand the law before you get to class. I should have said before here. Why? So you can focus on the really important things. People will write everything down indiscriminately in class because they don't know what's important, because the professor doesn't signal what's important, because you're still stuck, um, which is natural, with the kind of undergraduate mode of education where all of the facts are important. That's not true in law school. So again, pre-studying a commercial outline helps you uh, be more confident by the time you get to class that you're not struggling to understand the law. You can focus on these other things that will really give you an edge on the final exam. Finally, you pre or side study the law because it'll help you do TAPIOD. Uh, Other than buying my product Kit Cool, sometimes it's very hard to take a practice exam if you don't have some law under your belt. And for many students, it's the reason that they wait until the end of the semester. They're told by upperclassmen, don't even start taking practice exams until the end because you don't have enough law. It's a waste of time. You don't have enough law to do it. Give yourself the law to do it, but the way to do that is to pre-study using commercial outlines. Why are you going to do that? Because it'll help you do TAPIOD. It'll smooth the way for you to do TAPIOD. Why take a practice exam a day? Because it helps you build your issue spotting muscles. Why do that? Because it'll help you do well in the final exam. Okay? God help me, I'm going to try to diagram that. I don't know what that squiggle was or how it appeared. Um, so, um, let me get to something. Let's start. Your goal is good grades. And the reason I think it's helpful to pyramid, like to kind of show you, to draw this, is specifically to, so that you can see how everything kind of builds into this. It's not several pages of PowerPoint slides, but it's also, it's something that you can see, and you can see everything kind of feeding into other things. So how do you get good grades? You do well on your final exams. How do you do well on your final exams? You get good. Give me a second here. You get good at issue spotting. Sorry, I'm going to do this slower. Now, how do you get good at issue spotting? The most direct way is to do TAPIOD. To do TAPIOD, it helps to pre-study the law. To pre-study the law, you need to look at commercial outlines. Okay. But that's just part of the equation. You also do this other thing called read cases. So how does that fit into this? Why do you read cases? You read them to do, you get hypos. but you also get RGAs that help you construct outlines from which you get issue and case spectrums, which pretty directly help you with issue spotting. The hypos, I think, developing hypos from cases also, in my view, help you relatively directly with issue spotting. Coincidentally, pre-studying the law using commercial, undo, pre-studying the law helps you to read cases better. You've got this other thing here. You've got class. And you develop a bunch of things in class. You pick up on your professor's hypos. You've got rule statements that you use very directly on the exam. And you also have, let's just call this mastering the professor. Sorry. Mastering the professor is kind of all of these things, but this is the kind of favored means kind of or modes of argumentation. Okay. All that feeds into issue spotting. Oh, by the way, pre-studying helps with class. Okay. So I wish this were looked a little less like I was drawing with crayon. But this is kind of how I see the world. Everything eventually comes back to issue spotting. Now you can try. I'm going to change colors for a second. You can try to see how other activities work into this. Does it help to brief cases? What can you do with that? What does briefing cases, I'm going to make this a circle, help in the grand scheme of things? What's the path that allows, that kind of tells you that briefing cases is worth it because it'll help you with issue spotting? In my view, I don't really see it. I think it kind of just leads to an island, maybe marginally it helps. I mean, who knows? Class participation. Why are you reading cases obsessively? Or why do you reread cases like 3 or 4 times? Well, maybe that helps you with class participation. Does that help with your final exams? A little bit. But it's gonna, help like 1/3 of a grade at best. And you're not even guaranteed that. So I wouldn't think of it that way. So, I've presented before in older videos and other things as kind of, the triangle approach, with mastering the law being at the base, mastering issue spotting being the middle section of the triangle, and kind of mastering the professor being at the top. This is a different way of envisioning these same ideas, a lot of which I've talked about in the last couple of weeks. Um, but eventually getting to the point where this, let's see how this works. Nope, that did not work. Anyway, I'll leave that be. But this is my way of kind of conceiving of this. So let me open it up to general questions now. And I promise I'll make a kind of cleaner version of this available. So I can't see a name. I see AWTU123. Can you explain the abbreviations like TOPIOD and RGA? And then I've got Nicole's here, which is this what you did to get good grades, or did you learn the hard way? I want to get off of sharing this.